This one actually kind of, so when we met last month, we just kind of did our brainstorming on the fifth anniversary one, and it was a lot of what kind of other presentations would everybody like to see? And one of them was a little bit more like realistic survey problems, right? And so um, you had put this one together for September 24th, the daily quiz, and then Jerry had sent out right after that and goes, "Hey, this would be great for a Roundtable Tuesday," which we can never get off the ground, and we would have never had 26 people for Roundtable Tuesday. So this actually works out really well. But so it kind of twofold. One, it brings in some realistic conversation, and this one's going to be kind of hard to, I guess, navigate because there's so many different unanswered questions. There's so many different things. There's so many different pathways we can go with this particular question. Um, and so we'll have to kind of maybe we'll just start with a simple one and then we can kind of elaborate on others, right? When we get to original monuments and what holds and all of those kind of the rules of construction, like we talked about a little bit on there. But um, I'll share my screen because we have it was from, let's see, which page is it? Hold on one second. Oops. Cancel. Gotta find out which site it's on. Oh, there we go. Dun, dun, dun. There. Boy, like my first day. What happens when you take almost the whole summer off? Um, this was, let me slide this back over here. So I'm looking at it. This was Kyle's question, and it was it's a great question. And then Jerry kind of picked it apart and went a little farther with it, and that's when we kind of decided to turn this into a Mentoring Mondays conversation. And so the very first part of it, and I don't know if you want to give a much background on it, Kyle, where you might have got it from or how you came up with it and that kind of stuff, just to kind of help everybody with the background of it. But this was the one. If you didn't know which one we were talking about, Kyle.
Yeah, so full disclosure, this was probably written about a year and a half ago, be my guess. The last 3 weeks I've taken off writing new questions and I've been cycling in randomized ones from the past.
Okay.
But man, it's a spicy question.
It is. It is. It, it, it very much is. And so, for those, they can obviously you can see it on the screen, but Mr. Green owns a 100-acre parcel that is square in shape. He sells the north 50 acres to Mr. Blue and retains the south 50 acres. Years later, Mr. Green sells the south 50 acres. A survey is performed and determines the original property to have actually been a 110 acre square parcel. How many acres is the property of Mr. Blue after the survey? So this is where we talked about kind of junior senior rights, those kind of things. So the the whole thing on the first part for Mr. Blue, or no, actually, Mr. Green sells to Mr. Blue. So Mr. Blue, because it says the north 50 acres, is fairly simple, right? I think we can probably all agree on that aspect of it. And so to answer the question would be somewhat simpler. Mr. Mr. Blue, oh holy shit. Mr. Green he sells the north 50 acres to Mr. Blue. Sorry. It gets confusing when it says Mr. Blue retains. I get on that same sentence. But so Mr. Blue, in theory, would only own 50 acres in that aspect of it. But where Jerry wanted to really dig into it was a lot more. And I don't know if you want to kind of elaborate on that moving forward a little bit farther, Jerry, but I can probably stop sharing screen for a second and we can talk on
Yeah,
it a little bit farther. But
basically, what I thought about when we came up with this, let me get I guess my information. Um, if we look at the south 50 acres
yep.
interpretation, he says, so if he sells the north 50 acres to one party, and then later on sells the south 50 acres to the second party.
Exactly.
That's a sequential conveyance. So there's junior and senior rights that are established. And then later on, if it's discovered in a resurvey that there's 110 acres, what happens to the junior parcel?
And that's what,
We've already ascertained that the north 50 acres is going to be 50 acres.
right.
What happens to what that second party buys? What does that second party get?
Yep.
And I've run into a couple of different interpretations of that. And I have some theories on it stuff, and I threw out in the questions that I posed to Trent for this was how is the gap treated in any particular jurisdiction? Because
Yeah.
I think that could be different.
Correct.
And then how does the surveyor handle it? Say that you're hired by your client is the person that is the junior owner. What do you tell that person owns based on the way it's treated in your jurisdiction? So
And,
basically, I
and
want to find out how consistent that is across the country.
yeah, and to the point too, where going back to the question, he sells the south 50 acres, right? And so one
Yeah,
owns the north
yeah,
50 acres and one owns the south 50 acres, and it comes out to be 110
yeah.
acres. Does
Yeah,
the
because there's a number. Yeah, because there's a number of ways that could be conveyed. It could be conveyed as the parcel less than north 50 acres, or except the north
right
50 acres, which is interpreted differently potentially than the
north
south
half,
50
south
acres.
half? Yeah. If you would have said
North
north
half,
half or
south half.
sells the south half, that's a whole nother just a whole nother
Yeah, 'cause
conversation.
now you're dealing with proportions and not with explicit area calls, and that's
Yeah.
and when you think about some of the things that we have to interpret, to the lay person, those things may mean the same thing.
Right.
To the surveyor, they don't because they're explicit. My question is then to a court, how does the court interpret it?
Mhm.
Or basically, how's the jurisdiction? How's your common law interpret that? What is it?
How about you want to start with yours, Jerry? Just in Wisconsin? How would it?
No, I don't want to start with mine because mine's kind of an oddball type of thing.
Well, it may not be, but
But what I will start with is that in Brown's textbook, he offers contradictory discussion of that. In one part, he says, in the event of a gap between a joiner, court decisions as to which control have varied. Okay, so Brown's parcels here. So in some cases, he says a strip is created. Okay, it's never conveyed. In other cases, that if it's small enough, then it'll go to the junior owner, but not the senior owner. But if it's large, then it's not never conveyed. But they don't make a distinction between what is small and what is large. So in some cases, they say it was never conveyed. In other cases, they say, well, it may go to the junior owner. But they do put the disclaimer in. It says depending on the jurisdiction. So that's my question is I
yeah,
can tell you what some of the jurisdictional stuff is in Wisconsin, but I want to know what the jurisdictional stuff is and how consistent or inconsistent it is between different states. Because everybody's familiar with it.
James, you're Alabama, right?
No, I'm in
Oh,
Arkansas,
Arkansas. I knew it was
and
one of the
Same,
A's.
same,
Yeah,
same,
yeah,
same thing. It's one of those
uh,
A states.
yeah.
the
Alabama, Arkansas,
hypothetical
last name.
the hypothetical that we're talking about there, uh, to me, the court would view it as the intent of the grantor that sold the 50 acres. We get back to what did the grantor did he have a belief that he owned 100 acres? Is there
Exactly.
some evidence that shows that at one time or whenever he was making these deeds, he thought that he had 100 acres? If that is the case, and he sells the South 50 acres, then I think the court's going to interpret that as a sale of all of his remainder, and that guy's going to wind up with uh, 60 acres. But now, and then there's another part of it there, and that is actions of the parties after the sale. And one of them would be, was the grantor, did he pay taxes on 10 acres after he made that second sale? If he didn't, then I think it's another indication there that the court would interpret that his intent was to sell the remainder, and his intent is the factor there that the court's really going to go with.
Well, but couldn't we, based on that, on your discussion there, if he originally believed he owned 100 acres, when in reality he owned 110, wasn't his intent to sell the north half of it first and then the south half of it? So in reality, both would get 55 acres.
No, not unless that he had a plan whenever he did the first one. If he had a plan that he was going by that could be produced, then yes, I think that you could treat them then as being simultaneous conveyances, and you'd have to prorate it based on the things. This is one of the kind of easy thing. The thing that gets hard is when this thing happens like this, and there's not a gap but an overlap,
Yeah.
and then things can get complicated.
Yeah. Real quick, James, before there was like 5 or 6 that just jumped on probably within the last couple of minutes, so I wanted to re-share the screen for those that just jumped on, so you can kind of see the problem that we're talking about. If you want to read that, you can also go to. I can throw it in the chat. Let me throw this in the chat really quick. Again, for those that are jumping on, and you can go back and read this question. I'll stop sharing the screen, but George had his hand up, so he's gonna chime in. But for those that just jumped on, click on the link and you can go read the question.
That link won't be live anymore.
You just killed it?
Oh, I think it's over a week old, so it automatically dies.
Oh, well, I just got on it.
Oh, well, maybe I'm way behind on that.
Oh, no, you're right. I just clicked on it and it died. So
Okay.
But you can go to the website. That's how I got to it.
Give me 5 minutes and I'll make it live again.
All right. Well, there you go. Sorry. Go for it, George.
Okay. The whole thing really kind of hinges on two things. What did the owner actually think he actually owned?
Right.
And what was the bigger thing is what was the owner's intent? And, if you looked at this from the other side of the coin, say he only had 98 acres, the first deed would have conveyed 50 acres. The second deed would have conveyed only what was left that he had to convey, because you can't convey what you don't own. So the second buyer would have only received 48 acres. If the documents said the north 50 acres and the south 50 acres, that's what would have been conveyed. And to my way of thinking, that in this case that leaves a 10-acre piece in the middle, unless there was some reason that the first buyer and the seller got together and built a fence exactly in the middle of that parcel. Then there's evidence that there was some acquiescence or a difference in intent, that he intended to actually convey half of the parcel. But
if they got together and put that fence in there and there's acquiescence, that's a different doctrine.
Yeah.
That's true.
See, that's why I would say
you're now with unwritten rights.
Let's go
agreed upon boundary.
Let's go back to the original. Let's go back to the original.
Show intent if the seller agreed to allow a fence in the middle of across the middle of the parcel, regard if it's fencing off 55 acres or 50 acres. Uh, that's what the owner thought he had, and that's what he thought he conveyed. So I don't know. This is
Hold
a
on.
real can of worms.
I was gonna say, hold on, George. Dan, I see your thing in the chat, so I'll call in you in just 2 seconds. But go back to the original part, right? It's 50 acres, and it's the north 50 acres, and then he sells off the south 50 acres. In theory, there's a 10-acre
That's right.
gap, and so who does the original owner still own the 10-acre gap? I mean, that's
That,
another whole conversation that we can get down to, right? So that's why I was saying this conversation is going to be really hard to steer
yeah.
the boat, but
And that's
I
what
think
I
we
put
want
in
to.
the chat earlier is that
Yeah,
there's three parcels.
correct. Dan, you're trying to chime in there, so I want to go to Dan before we go to Jerry. Oh, now you're muted, or you must be muted on a mic somewhere because you're not muted on Zoom. Nope.
We can't hear you, Dan.
Yeah, nothing yet. It shows that you're not muted, but do you have an external mic that you're using? Oh, let's see. What do you say?
Does
Go ahead,
anybody
I'll
hear
find
me
it. Go
good?
ahead, I'll find it. You got it. Dan will come back in a second. Go for it, Jerry.
Going back to a couple of George, Dan both said, with respect to area, how many of you, when you write a description, put an area code in and then put in plus or minus after approximately?
More or less. Yep. Depending on the
More
terminology, but
or
yeah, more or less. But we have state law. Oh, we're losing you, Jerry.
less. So, I mean, he could believe he had 100 acres, but if it beats those, yeah. Yeah, see, that's just it. That again, jurisdictions, more or less, the
Yeah.
person's gonna think they own 100 acres, potentially. And maybe acting based on that, even though there might be error in that 100 acres.
Yep. So I brought this up at the office earlier with a couple of guys, and they immediately went to, because we're in the West, they immediately went to sectional breakdowns and like, 100 acres. Well, that's, 80 acres plus 20 acres or something like that. I'm like, you got to go, you got to think of even colonial states, right? Like
Just
somebody cutting out a 100-acre parcel in the colonial states versus just sectional land and those kind of things. So um, we had fun with this one in the office today too. Oh, the link should be live. Let's see if it's live again. Yeah,
Dan
you
says
were.
raised hand was, it's under React. If you go to the React button, that's where the raised hand tool is.
Oh, there you go.
Yeah. And that's where the clapping is too, I guess.
I like it. I like it. How about now? You're still muted on Zoom, Dan. You want to try again?
So how about now?
Yeah, we're in now.
There we go.
Oh, yeah. Okay,
Yeah,
take
so
over. It's all yours now.
under my React, it says play chimes when hand is raised and recognized hand gestures. Nothing has tell me to raise my hand, so no idea. So I want to go back to the comment, the gentleman that says PLS 8XX.
That's James. Yep.
James, you said was the owner, I'm going to say to the south, was he paying taxes on those 10 acres? As far as I know, because I ran into this up here in Iowa, that the assessor doesn't change the acres on their tax documents here until it's been surveyed. So would you even know if he's been paying taxes on 10 extra acres if it wasn't surveyed?
Oh, interesting. You're muted, James.
Well, you would think that the tax guy would pick up the first 50 acres and then show two tracts there for tax purposes. One 50 acres and the other one maybe 50 acres too, if that's the best information that he's had at that time. You understand what I'm saying there? It makes a difference.
Yeah.
Did they
Yeah.
start with thinking they had 100 acres, or did they start thinking they had 110? If they started, say, thinking they had 100, the tax guy is probably going to show it 50 acres in one tract and 50 acres in the other tract. That's what he's
Right.
going to have on the tax rolls. Then with a second sale, depending upon what it says, if it says 60 acres, he's going to change that 50 acres to 60 acres, and there's still going to be two tracts. If it started out with 110 and the second one says 50 acres, he's going to show that on the tax rolls as three parcels and one as 10 acres and expect the original grantor to pay taxes on that 10-acre tract. If he does, that's a good indication that there really is three tracks.
Yeah.
And it's one at each 250-acre tracts and one 10-acre tract. Uh, does that make any sense?
Talking about after the fact. So I think where I'm stuck at is we're still in the assumption that everything's still 100 acres until Mr. Green decides to survey it, right?
Yeah. Correct.
So, okay, yep. I guess, and now I haven't been lucky enough yet to get called to court, but as far as the stories that I've heard, the judge isn't really going to care what we measure too much is if they've been acting like that fence has been there, smack dab in the middle, no matter what that fence is at, isn't that likelihood that's what the judge is going to go with anyway, or am I?
No,
There's
wait a
something
second.
else
If
I'd have to worry
George
about.
added the fence, the original problem didn't have a fence. George added the fence.
But either way, they farmed up to that 50 acres. There's got to be
Yeah.
a change. There's got to be a different breed of corn or something. Beans on one
But
side, right?
but do lines of possession match lines of title or ownership?
Which
I always
should have
look
been
at it.
55 acres each.
I always look at it as when you do a survey, there's two boundaries on almost all surveys. One based on the record title, sum of everything that's recorded, and one that's based on everything else, whether it's adverse possession or boundary line agreement or acquiescence or whatever it is, something other than record. There's two in there, and each one of them has to carry on its own weight. One of them will win and one of them won't, but it has to carry its own weight. So the first thing is you look for the record line, and then you look whether that still holds in face of all of the other things that might have happened.
Yeah. Good stuff. We got a couple hands up, so I'll give me 1 second, James. But there is one in the chat. In Indiana is very similar, deeded acres. Unless the survey says otherwise, the assessor can order a survey if they believe it may be way off by the deed. So similar to you, Dan, in Iowa, like kind of based on surveys and deeds. But that one's a good one from Jared in the chat. Kyle, you want to add some more fuel to the fire?
Sure. So this is for the benefit of people actually sitting for something like a PS, FS, or state-specific exam.
Correct.
The answer in real life is always to go find more information, find more evidence, dig deeper, find more. In test world, you don't have that option.
Yep.
And so the answer in this case is to follow, is 50 because that's what he was granted and nothing more, right?
Yep.
If I surveyed this in the real world, yeah, I'd locate a fence if I could find it. I'd find any available evidence and build something and try to solve the problem. There are a lot of people in the state of California who differ on what you would do with a gap like this. The civil code is pretty clear about what can be done regarding intent, which is we don't read intent outside of the four corners of the deed. That being said, in personal practice, sometimes it makes sense to solve your client's issues instead of creating more. So it's up to the professional to determine what to do in the actual situations. But if you are answering this in the test, you need to kind of remove yourself from all of those things. I love this discussion. I want it to keep going like we're not in a test environment.
Yes.
But in the test environment, man, like don't think like a surveyor, think like a person who's going to pass that test.
Right. And that's why I went back to the original part, which is the original North 50 acres, right? Because that was the first piece that was transferred. And so from an exam standpoint, right, they're not really gonna trick you with that much
And that's
they,
why I don't ask the reverse of this question, which is,
correct.
you know, that makes you wade into who owns a gap, and that's a
That's
question
why
of
we're here.
yeah, that's a whole different that's the spicy part, right?
Yeah, yeah, that's the spicy part. I know, I love it. Uh
That's that's one of the reasons that I hesitated to ever break into this mentoring thing, because here we have a bunch of people that are really going to try to take the test, and the things that I might say might confuse them when they need something that's kind of simple to get through that test. Now, once they get their license, then I'd love to talk to them about some of the
yeah.
issues that we run into in real life. But gee, I'd hate to confuse somebody before they got ready to take the test.
Yeah. Those are two different, really, like Kyle says, there's two totally different worlds. Like there's a there's it's unfortunate that there is that much, but
The the whole idea of junior senior rights is a survey principle,
yep.
because I say that because of after many years of reading court decisions, I never see this particular uh, uh, thing where they use the language of junior senior rights over a boundary. I see it in some other things, but I don't see that language used in court decisions. They use a different thing. It's the same idea, the same uh, what they're trying to accomplish, but they use a different language, and it really doesn't matter whether you use principles of surveying or principles of law. 99 times you will come to the same conclusion, but in that 100th time, you don't. And when you don't, if you're in court and you're trying to put forward principles of surveying, you're going to lose. I'm telling you, you're playing in the sandbox with the attorneys, and their rules go there.
Yep. For anybody who wants a lot more nuggets of James's information, go watch any Wisdom Wednesdays. James was very opinionated during Wisdoms, and he was very informative on all of his years of experience. So it was great. Dan, you had your hand up for a while. Go for
I finally hit a chat button. I kept pressing the arrow next to the chat button, so the whole chat button is what you're supposed to press, or the react button.
it.
Kyle, going back to a comment you made, I just want to get a little bit more information on that. You said something on the lines is the intent is outside of what we do or something like that. And I was wondering if you could elaborate on that a little bit more.
So this is not my opinion as much as it is maybe closer to, I've seen this argued by older, smarter surveyors than myself. Um, Typically, I've seen Dave Woolley with the opinion quite a bit that um, as surveyors, we don't leave the four corners of the deed unless there, like Steve said in the chat, unless there is a latent ambiguity. But if I sell you the south 50 feet, the neighbor gets sold the north 50 feet, and it turns out it's 110 feet long, there is no space for me to go outside because I haven't found a latent ambiguity. That is the argument against gaps being going to the junior. right? And Dave would say that to me probably 100 times. Like there's nothing in California law that states that the junior gets the rest. Everybody gets theirs, and he would resolve it via a lot line adjustment. I can find probably just as many surveyors who say the exact opposite. So
Yeah.
take
Yeah.
everything with a grain of salt. It's all situational, but yeah, that's the fun of gaps. And overlap, I think, is actually easier to deal with than a gap every time.
So when do we, like, I come up to this every once in a while. You find the pins, right? And then there's a fence right there, or there's a bush. Everybody thinks that that's the line. They lived there for 15 years, so well past the statute of limitations. So when do you go out and say, um, well, first I would say go talk to your attorney. They're the ones that are going to decide it. If you guys don't agree, I can't figure it out for you. But when do you go out and say, well, here is the way you guys have been living, but here's the pins. So right there, you're upsetting the neighborhood just because somebody wanted to find their lot corners, right?
And I think that was going to be kind of the third option was what if we have found the original four corners, right? I mean that would be like option number three, and that's how we would continue this conversation. Now we find the four original corners, and it doesn't come out to be that 100 acres, and it was. But then that assumes that Mr. Green had a survey done, and he knew it was 110 acres at that point, right? So, I mean that just adds a whole nother 2 hours of conversation to this thing. But go for it, Kyle.
Yeah. Take that 50 acre section and turn it into 50-foot sections, and then turn it to 5,000-foot sections. And, play with how large that gap is and figure out where the level is that you care. And at what point can you actually read intent into a gap, right? And it's kind of an interesting thing because it changes with where you are in the world. A foot has a lot more value in some parts of the world
Yeah.
than others. So it's super situational. But if you look around on the CLSA forums, there's some really good arguments on there for both sides, and I'm frankly somewhere in the middle most of the time, where it just
Kyle, do,
depends. I'd
do
rather go find more evidence.
do they have to be a member to have that to get onto the CLSA forum?
I don't think so.
Yeah,
I think
Dan, that's Dan. It's
alt-ly.
California Land Surveyors Association. I don't know if Kyle, you want to throw that in the chat, and I can click on it. Although I'm a member, so I won't. Jerry, you want to elaborate on your Supreme Court case you threw in the chat?
Yeah, I just want to, in response to James, what he said about, not using the junior and the senior right, that's something that we talk about. I just did a quick search and I found a court case in Wisconsin, 1985 Supreme Court case, where they did in fact use that language, where they recognized a junior right in a property dispute situation. So, although it may not be standard terminology maybe that's being used in a court system, they recognize the fact that there's hierarchy based on the creation of the boundaries and that type of thing, at least in this particular case. And it was, like I said, 1985 case, which is relatively recent. I do want to throw out a couple of comments here with respect to some of the discussion that has been going on. And we're doing exactly what surveyors do. And that is,
Yes.
okay, now, was there a fence? Is there corners? Are they original corners? All that. Wash all that stuff away, because none of that is the original problem statement.
Right.
The original problem statement is 100 acres, north 50, south 50. Nobody said anything about monuments. Nobody said anything about putting up fences or anything like that. You're right. And we looked at additional information. We're just looking for something that's clean here. And it doesn't matter if it's 100 acres or 10 acres or whatever. There should be some consistency. Kyle again brought up the thing about how much is a foot worth, I think that goes back to some of what Brown was talking about in depending on the size of the gap, is that a remainder of the original parent parcel, or does it go to, say, the junior parcel? Now, if you read Lucas's book, Lucas contends that the courts consistently say that that will go to the junior parcel. And I don't think that's necessarily true. Okay. And again, Brown to a certain extent contradicts that, even though
Oh, Jerry,
Lucas,
Jerry,
I think, has got two court cases, one where they argue. Yeah.
turn your video off. You're breaking up a little bit. You're missing a few words.
Okay.
There you go.
All right. That could very well expect I'm in the basement. Is this better?
Yep, that's perfect now.
You don't need to see me anyway. I'm just impassioned waving my arms around. Just picture me waving my arms around.
We get it.
But anyway, so let me tell you what a court case in Wisconsin did with respect to this. They split it between the senior and the junior parcel. They didn't proportion it. They split it down the middle, regardless of what the two pieces were. So going back to, somebody said, the senior rules of construction. If you look at the rules of construction, the way Brown has got it, at the top is unwritten rights. Okay. Next is what? Senior right in the event of an overlap. He doesn't say anything about gaps. Then he gets the written intent of the parties. Okay. So now we're in that area in between where we're dealing with a senior and junior right, but there's not an overlap in there. There's a gap that's created in there. So we feel comfortable saying if there's only 90 acres, then we know the junior owner only gets 40, right? Because it's the senior owner. But if it's 50, if it's 110 acres and the calls are for North 50 and South 50, okay, then what? And then we can the reason the deed exists is because the statute of frauds. The statute of frauds says contracts have to be interpreted based on their written terms. And you can go to any contract law case decided by a court and they'll say we're bound by the terms of that contract. We cannot read outside that contract what was in their minds. So does that mean that a 10-foot gap does exist in between because it was never conveyed, because it was never worded to convey that? So I'm getting out there. This is why this is one of those squishy things.
Yeah, and that goes back to Kyle's point about the four corners of the document, right? So
right, yeah.
Yep.
And anytime you pull in, Trent, you mentioned like they're talking about sections now, that doesn't apply because those are simultaneous conveyances. Whenever you create an aliquot part, you're actually creating more than one parcel at a time.
Right.
This is not a sequential, this is not simultaneous, this is a sequential conveyance.
Nice.
Okay. I didn't mean to shut everybody up on that, but I mean,
nope. You're good. You were just breaking up just a little bit towards some of the middle, so I think everybody's just trying to catch up with where you were. Now we lost. Oh, Jerry went mute. What there's quite a bit in the chat, and I'll make sure that we capitalize some of this in there as well. Jerry in the chat, how would equity factor into this? Question for you there, Jerry.
You want to answer for? Okay, let me ask you this.
Oh, go for it. You lost.
There are matters of title and there are matters of survey. Okay? Okay, can you hear me okay?
Yep.
When we're talking about unwritten rights, does a surveyor determine that? No, a court decides that. Why? Because that's a matter of title. Right? Who gains title to land based on ownership? When it comes to written intent, where we're interpreting the deed and evaluating evidence, that's a matter of survey. My contention is that senior and junior rights are between those two. between a matter of title and a matter of survey. So at that point, then, as far as equity, right? Surveyor doesn't decide equity. I don't get to decide what's an equitable solution between the two parties. I have to act with respect to what the deed says and what the evidence I can gather that can help support that. In Wisconsin, the minimum standards for survey says that I will reestablish lines according to the record of the Register of Deeds. It doesn't say that I have to make equitable determinations on anything. That's a court decides that. That's a matter of title, not a matter of survey. So equitability, you know, I think that's outside the surveyor's purview.
No, yeah, I think you hit it based on Wisconsin code. You definitely hit it. I do love when the Zoom catches up and he just starts spilling words. That's pretty funny. Sorry. Uh, it catches up with you, and then it just like that's awesome.
Yeah, my wife kind of reacts the same way. So
I love it. I love it. All right. So there's a bunch of you without cameras. Who else wants to kind of chime in? I know Harmony threw in the chat very early about who pays for litigation. Uh, and I guess that goes back to whichever owner wants to fight at that point is going to be the one that pays for litigation. So um, that's always an interesting one. I'm trying to think of what else was in the chat. Steve had a bunch of good stuff. Where else? Was the deed written before the survey was performed, a paper survey, or after the survey was performed? Again, that adds another 2 hour conversation, Will.
I still think we're stuck with the two documents,
Yes,
and
agreed.
what they convey, they convey.
Yeah,
You can't you can't have a document that conveys 50 acres that conveys 55 unless there's some extreme situation. Uh, so it comes down to the fact that this problem can't be solved without a survey to determine the fact that there was 110 acres there unless somebody knew that beforehand. And evidently nobody did. So it's on us to help solve this problem. And the first buyer gets their 50. That's without question.
yep.
The second buyer gets what they were conveyed, 50. I think that's without question. And the fact that there's an unknown 10 acres in there falls on the grantor, and I guess he's stuck with it.
Yeah, and he may have the 10 acres. Jacob Harris, you had threw in the chat. Um, they had done a survey in Virginia where they found a parcel that had 10 additional acres after we finished the survey. I don't know if Jacob, if you want to unmute or elaborate on that anymore, but
Yeah.
and what you thought
Well,
the end result was?
I was kind of surprised by the end result because a lot of it it was a residue parcel that we surveyed, and this residue parcel came from so many out conveyances from many of the adjoiners that when it finally came together, um, in a way there could have been a large gap, but it being a meets and bounds state,
Yeah.
that's just kind of how it ended up. Indian GIS was wrong. Tax maps nothing really reflected, and it was kind of a big shot to take on. But it was really interesting how it all came together.
Did they get the extra 10 acres? Who
They
was
did.
the last person? Your person that your client did?
Yeah, our client did. They got the 10 acres.
Gotcha.
And a lot of it did fall into like occupation. There was more than just the junior senior rights. We had old fence lines. We had other things that we could go into to help determine our survey.
Yeah. Very cool. Yeah, and that was kind of what we alluded to in the beginning too. there's so many different things, West Coast sectionalized land, meets and bound states are going to, especially in your situation where it sounds like it was, might have been broken up. This 100-acre parcel may have been broken up 6 times, right? And this was happened to be the last piece that was cut out of it. But um, Steve just threw in the chat as well. As mentioned, it's a test situation. So going back to the very part of Kyle's aspect of it, just don't get too far outside the question when you're answering a question. That goes back to that. But asking about a survey principle of minimally competent surveyors should know though, and that's so at least in the end, that first part of that question and like you wrote it, it's Mr. Green owns that 50 acres because that's what he was given, and it again, changing the answer or changing the question to say north half versus south half. Now we're on to another. Now we're on to another hour
Different
discussion.
situation.
Yeah, go for it, Kyle.
So I think we've got a couple Bay Area or former Bay Area and California Bay Area surveyors in here, and they can tell you that when you get into these rancho areas where you have a whole block that has been re-subdivided by deed and different, sometimes it's west half, sometimes it's west 50 feet. There's so many spots on an entire block that are just covered in the smallest or overlaps and gaps, and it gets down to the concept of de minimis, like, does this really matter? Is this a large enough thing to need to fix? And I think it's a shame that he's out scuba diving, but Ian Wilson would be
Yeah.
a great person to have, talk about this, because he gave a whole presentation on Mentoring Mondays about a record of survey that would, if you tried to fix it by you survey the entire block, there's no way to do it in a way that conforms with California's civil codes.
Right.
So, yeah, I'm curious if any of our Bay Area experts want to weigh in. I think Steve Martin's formerly EV Mud, is that right?
Mm-hmm.
So, and Rob Hanley's in San Francisco. Yeah.
See if a couple of there you go.
Yes, I used to work at EB Bud, but Rob Hanley used to work for Ian Wilson there, so maybe he can.
Ian will watch this later, and he's going to be mad that he didn't jump on here.
The survey principle versus what the lawyers always say. What I get from them is that this hierarchy between consecutive deeds is you can't convey, a grantor can't convey an interest in real property that he himself does not hold. That's the way they say it. And in most cases, whether you call it junior senior rights or you state it in the way that the attorneys like to lay it out, you come to the same conclusion, except when you have an overlap and the original grantor sells to two different parties. You've got the first party, he gets his because he's senior. The other guy takes the junior part. But where the common grantor then goes back and buys back the first parcel that he sold, if there was an overlap, it's the second guy that gets his, and the other guy gets the remainder. So it turns the junior senior thing upside down, and that factor there is called estoppel by deed, or uh, after acquired title. And so you're rarely going to see it, but it's there. And that's the difference between surveying principles and legal principles. I don't want that to bother you guys that are trying to take a test. Take the simple route till you get through that test. But just know that on the back side of this thing, it's not going to be that simple.
Nobody wants to chime in on that because it's so true. But uh, Rob, we do want you to chime in. Come on, you can unmute. He threw in the chat. You don't want me chiming in on this.
Okay.
All right. Yes.
Geez. Yeah. Well, thank you. That's very kind of you to think that I have anything to contribute. I mostly, by the way, it's warm here in San Francisco. It's almost 80. So,
It's 82 in Las Vegas. So yeah,
get out. Okay.
that's ridiculous to be that warm there, though.
Anyways, yeah. This is, I'll just jump ahead to the situation I have frequently encountered. I was the county surveyor or the chief surveyor for the city of San Francisco for over a decade. Had 5 years experience before that building Mission Bay, and then 2.5 years with Ian Wilson at Alameda County, and we both cleaned that up, and now Paul Mabry is in charge over there. Thank goodness. But one of the problems I always have, I just had this conversation with somebody the other day, and I go to the school of Jerry Mahon. I'm just like, I watch all your presentations and I read.
Oh, you poor sucker. Yeah.
And Jeff Lucas and John Stahl and Gary Kent. I mean, I listen to all these people. I listen to all these, and I've read hundreds of court cases, specifically in San Francisco, because we have such a situation here that's people just don't grasp. And that is when reading the data. Personally, my opinion is, which doesn't hold water at all, but I don't like the term unwritten rights, but I can't think of another term to apply, because what it is that somebody thinks they own something for some reason. They were granted property by a deed, and the deed to me is secondary always. It's like, okay, what's the intent of the deed? And I repeat this over and over and over. The intent of the deed, the intent of the map is to show what's really on the ground, what was really conveyed. So in these types of situations, there are so many cases that indicate that when the buyer goes out with the seller and they walk the property, as Jerry used to say, the meets and bounds, the beating the bounds, I guess the term was.
Mm-hmm.
But the owners and the owner and the property, the person buying the property, they look at the property, and that's what is conveyed. And what I keep saying to people over, and this is not a test question, by the way. If you're studying for your test, just put this in the back of your head, and after you get your license, then you can get dirty and start talking about this stuff. But to me is what is on the ground, and that has been held up in court cases and court cases and court cases for a century and a half in California. And so I keep saying to people, what's on the ground? What do you have that shows the intent of the original owner and the original buyer? And in San Francisco, the great percentage of the deeds are meets and bounds. And unfortunately, we have a situation where people always just hold religiously those distances. And I'm like, no, 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 no. Did you look at the property? Did you look at the block? Where is the block? Where is this property in relationship to the block? It's not off. People showing distances off I am not joking. I saw one, they were showing the tag off by 100th.
Oh no.
And I'm like, I'm serious. I am dead serious. That's why we had Jerry lecture us last year on least squares and accuracy and precision. But that's the kind of situation that I run into all the time. And I don't know if what I'm saying has any relevance to our conversation, but I just wanted to throw that in as far as that's my consistent experience. And as I said, there's tons of really interesting cases in California. Um, Three of my favorites are Arena v. Santa Barbara, Price v. DeReyes, and I'll think of the next one, Young v. Blakeman. I think those are the top three of my favorite cases that explain everything that I was talking about and um, uh, fortify, if you will, my expression of or my interpretation of deeds and property ownership, etc. So now, aren't you sorry you asked me to speak?
Oh, that was amazing. I do. And as Lucas would say, and as everyone you mentioned, Gary Kent, Stalls, all of those, right? As surveyors, we fall in love with numbers and not so much as intent and or lines of occupation. There's certain things like that, right? We just fall within that, as you said, somebody calling off a monument off by 100th. I know that happens early on with a lot of new surveyors. I know I can recall even on some of my first record of surveys, I wouldn't have called something off 100th, but I would have probably called it off, uh, a tenth by a tenth or something like that. But I will say, 20 years later and 30 years in the profession later, I will not, that will no longer be a delta of 10 by 10 off. But so those are fun, but you definitely grow. You're young and shy and gun shy as you first get your stamp, right? And so those things change as you become more seasoned. That's for sure.
Yeah, and the last thing I will add is I keep telling people I'm the president of the local chapter, and I put a lot of court cases into the newsletter. And sometimes I've used some really obscure stuff. There's a guy named what's his first name? Can't remember his first name. His last name is Weir, and he wrote this great article about agreements. And it's a 1916 article from Cal Reporter,
Mm.
and he was it was a fascinating article, and he wrote it it was funny because he wrote it as rebuttal to somebody who wrote in the Cal Reporter the month before about adverse possession. And so he writes back the next month, like, no, it's agreement deed. And so that's a fascinating case if you can look that up. WEIR, Cal Reporter, 1916.
Oh, nice. Okay. Can you shoot me that one, Rob? Will you shoot me that? And I can send it out in our next email too. Steve.
Let me see if I can find it.
Okay,
It's been a
go.
while since.
Yeah, no worries.
It might be paper.
Yeah, right.
Sorry.
That's okay. We'll figure it. Steve, at one point you had your hand up there, but you still want to chime in there?
Oh yeah, it's getting away from test situations and more like, it's just not always that easy or straightforward. And what Rob says, what do you find in the field? Years ago, even before I was licensed, I worked on a survey in two of the main deeds, um, east, let's see, west 10 acres and east 30 acres of northeast quarter, said section. According to an extension of the U.S. Public Land Survey System, over said rancho, reputed to have been made in May of 1888 by Owen Sanford, right? So it's just not that simple. And so is it federal rules or is it, state rules? And here I'm, wasn't quite licensed yet. I got west 10 acres, east 30 acres, and I got a 41 plus change acre quarter section in there. And I give it to the boss. Hey, we got a problem here. There's a big gap in the middle of our airport. And then the boss, he got hit by a trolley, never came back to work, and you know, finally I pulled that survey out years later and finished it up, but it's just not always that simple. You're not going to find that that perfect 10-acre gap there. There's extenuating circumstances.
Oh, for sure. For sure. Kyle, you just threw a PDF in there. Can I share the screen and we can talk about that one really quick?
Yeah, this is in, I think, Placer County somewhere. Didn't end up being anything I had to work on, luckily, but yeah, just somewhere where I see unknown ownership on a map, and I kind of wonder, how did this come about? Um, I'll add another one in that shows that same
Oh,
question.
right here. Okay, I gotcha. I was
Mhm.
looking for it really quick, but yeah, there's a 2,600 foot. Oh, almost 2,600 foot gap by what? How? What's the other side?
40 feet, something like
Yeah,
that, 58.
yeah. 30, 38. We'll call it 39 just because you can't read it, but 39 by 2,657. 43, 560 divide.
Yeah,
I've seen stuff
Two
like that
two
in the
point three
Bay
seven
Area.
acres. Yeah. And yeah, interesting. So they didn't, and this map was recorded. When did it get recorded? 59, is that what I first saw or something?
85, I think.
Yeah, 85. Okay. Wow. Interesting.
Mm,
I've
It'll
seen it
be
in the Bay Area where it came down to a new center line for the road. The road was shifted over, so there were two essentially record center lines. And if you didn't do all the research and figure out where the two center lines were, you could have something that looked like that.
Yeah, you had threw that in the chat earlier too, Steve, about saying 10 acres later. Um, sorry, it was just opening up Rob's thing. Holy moly, it's 23 pages. All right, Rob, can I share this and you can talk about that? No.
Yep.
There you go. Built up boundaries outweigh paper boundaries. Oh, I love this. Okay.
And then there's the link to the court cases that are mentioned in that article.
Oh, got it. Okay.
And if you'll note, it's, as I said, it's 1916, and I had a discussion with somebody important. Golly, no, no, don't I sound like Trump, don't I? Anyways, no, I had a conversation with somebody whom I really respect regarding agreement deeds, and we were talking about this, and I said, 1916, that was like how many? That was like 5, 6 years before Clark's first article, 1922, his first treatise. And I was like wondering, I was listening to a lecture by somebody else, and they were talking about people being in the audience when people were talking about, particular cases and stuff. And it's like, I wonder if that's a rabbit hole. But anyways, these are really important cases in California, and one of the things that he mentions in the article is that the built-up boundaries, the occupation of the property exceeds if it exceeds the statutory period of time, and the statutory period of time in California is the civil the what is it the civil procedure 315, which was written in 1872. So, they're talking about statutory rights in 1916, but if you look back at the original legislation, it was written in 1872. So, again, my discussion with people all the time is like, you really need to know what the court this is my take, is that you really need to know what the court is going to say as part as your survey. And when Jerry was talking about equity, that's exactly right. But it's a court determination. But what I'm going to do is I'm going to look at that. I'm going to say, well, it's this, but what the court's going to say is that. And
Right.
if you really want to go to the mat on this, I'm going to tell you the court is going to say X. So it may be a good idea, it may not be a good idea. And the last thing I will say is that I had a great conversation with Gary Kent, and we were talking about agreement deeds because that's what I advocate a lot in San Francisco. And I said, yeah, you both sit down, you sit down with your neighbor and you decide where you can live with the property. And Gary's comment was, or where you both can't live with it, but
Yeah. And that goes back to John Stahl, where he was really an advocate for mediation and getting the property owners to agree, and that's John Stahl's take as well, right? So, and then Lucas's take would be, don't fall in love with the monuments, looking at all the deeds and all the references, those kind of things. So this is I knew this would be a pretty crazy conversation. I do want to throw, I'm going to share a screen because as, oops, hold on. Let me find the right screen first. Stop. Hold on. No, I messed up my own stuff. Close this. I went with, I did a chat GPT that they wanted to see. So I threw in your question. I gotta close this one. I threw in your question, Kyle, into chat, and you would be actually kind of surprised of what the answer says. And now that I have my right screen, property ownership. So all I said was, who owns what in this scenario? And then I just copied in your question. And it goes through step by step as we're all learning this AI stuff and how much farther and more impressive it's getting. But it goes through each scenario. Mr. Green owns 100-acre square. He sells the north 50 acres, but he does go on to say how this division was made. The key is how the north-south division was established. Mr. Blue's north 50 acres was described by acreage and not a fixed boundary line, i.e., the north half. And then it continues on. So going back to the original part of the question, Mr. Blue receives the exactly 50 acres as his deed says the north 50 acres. So it was pretty interesting to Mr. Blue owns 50 acres and Mr. Green and or his successor owns 60 acres. This is the loaded part, of course. But we all know from the very beginning in the first 5 minutes that Mr. Blue owns 50 acres and the question when it becomes the rest, who owns the rest. But I thought that was pretty interesting to see what chat had to say about that question. So in the end, Mr. Blue, which is what your question is, when it comes to a survey exam, Mr. Blue owns 50 acres. So
And people tell me we're not replaceable by AI.
There's
Well,
just one thing I'd like to leave with this group
Go for it, James.
of the experienced PLSs, and that is tonight we've talked a lot about court cases
Mhm.
and how that controls what we do as surveyors. And so we go and read court cases. Well, I think sometimes we're misled by that. And the reason behind that is we need to understand what courts do and what they don't do. When I first started reading law cases, boundary cases in the mid 70s, I was badly disillusioned there because I'd listened to the judges that were run for reelection, and they were all talking about justice, justice and fairness. And the first thing that I got out of that was these guys aren't being fair at all. It's not about fairness. Uh, that's not what they're aspiring to. And that upset me a little bit. And then I realized that they only handle two different really things that they're trying to do. One is precedent, that uniformity of decisions. And second is finality. Once the appeal process is over, it's done. And I don't care. You can't go back and reliterate it. So if a boundary is decided by the court, you can forget it ever being all this statute figuring out the record and everything. If you're past that, it no longer matters. The only thing that matters is what the court said. But courts, they're going to try to do something that's uniform there. They take the pleadings that are so important. It has a complaint of things that are asked and then allegations of fact. And those parties have to stay within those bounds because the court will only consider what was asked of it, what was it put before it in pleadings. In other words, the two parties may get together and they may have some cock and bull story and go off on left fields or whatnot, but the court is not going to write them up. They're not going to say, well, guys, you don't understand the situation. This is the law over here. No, it don't work that way. They pick the side that has the most reasonable and connection of prior law precedent with facts. And that's what gets done. But there might be a different argument that would have produced a different result. And that's what you need to understand, that it's what the court says is based on the pleadings, what legal argument was made, and what the facts were. If you change the facts, you change the result. If you change the argument, you change the result.
Sure.
So when you read a opinion of the court, you have to be knowledgeable about what was being pled, what was being argued, because if the argument was bad, then what you take away from it as far as being what the court said, that may not be uniform, because the next time you get a case, they're making a different argument and it looks totally different. But the court is doing the right thing. They solved the dispute based on the parties before them. And so I want to caution everybody there, because a lot of these appeals courts and Supreme Courts that that we look to for precedent, they don't always indicate real clearly what was the argument that was made on the facts. And so you got to kind of look for that in there. They're not real good about pointing that out. They're real good about talking about the facts of the case and what principles were applied to it. But they're not real good about telling you what the argument was. And so that's something you need to caution yourself about when you read these reports.
Good stuff. Good stuff, James. I love that. Jerry and then Will.
To kind of follow up on what was just said there, the judge reacts with respect to the evidence that's presented to them, and it's the side that can make the best argument for their case or for their side that's going to win. You can be as right as you want to be, or as right as you can be, but if your attorney can't make the case or can't argue it, and the other one comes off with more credibility, you're not going to win the case, which is why it's important that if you do read case law and you do wind up in a situation like this, that you inform the attorney in as much as you can about that stuff as well as the surveying stuff to have them as prepared as possible. Talking from firsthand experience with having to deal with the attorney as an expert witness and that type of thing, an unprepared attorney, even though the arguments may be on your side, isn't gonna win you the case because it's going to be based on what the court has presented to it. So any information that you can give your attorney to better prepare the argument, I think is going to be beneficial not just to yourself and to yourself, but to your client that you went into court with for.
Yeah, good stuff. Will, go for it.
Hey, yeah, I just wanted to say that, you know, I was a nervous wreck the first time I had to go to court. I was brand new and, right off the bat, I get pulled into this nightmare. And, the attorney just sat me down and she said, look, the only person in the courtroom who knows less about surveying than you and I is the judge. And I didn't really, I took it with a grain of salt. But when we got to the courthouse, I mean, that judge had seen, 3 divorce cases. There was guys walking out of there in orange jumpsuits before we went in. So, it was good advice. Like, the judge doesn't want to have to make a call decision. She wants you to present the evidence. He or she wants you to present the evidence so that they don't have to. And so, once I got in there and saw that that's, really what goes on. And again, to James's point, if depending on the circumstances, the judge will make a decision and it might not be the right one because there wasn't enough evidence presented. But now that's case law. Now somebody else might try to use that. But you really got to look at that and realize that, we're taught so stringently all these boundary laws. But a lot of times when you get in there, it's, they got a lunch appointment after this and they want to get out of there. So whichever side can make that decision and present the evidence to them is how that's going to work. And then also this is a test question, right? So I remember being the youngest guy in a surveying class, in a boundary class or a legal class, and everybody throwing, scenarios into a test question. And it's, it's confusing, but it's good to take with you. And yeah, it's, you'll see that question 100 times and you're going to get 100 different answers. So just take it easy. And if you ever get in that situation, just, realize everybody's a human. And, if you did your survey like you were going to go to court in the first place, you have nothing to worry about. So,
Yeah, and I say that a lot, right? I said that on all of this. The survey has to be defendable before it leaves your office. So,
yep. And you're probably going to be one of the smartest people in the room. You should be as an expert witness if you get, pulled into one of these. So, use that and don't be scared.
Kyle just threw in the chat. This might kind of sum up the whole night, but from evidence and procedures regarding intent, surveyors do not ask a person what was intended. The surveyor reads the documents that were signed and takes into account explanations and extended ambiguities and legal and survey. Oh, sorry, the chat's coming in behind it, so I'm the thing keeps moving on me. The legal and survey meanings of words and phrases. Then the surveyor decides what the written intent was. The written deed is conclusive evidence. Verbal testimony is of no avail except to explain extringent latent ambiguities or to explain a condition existing as of the date of the deed. Sorry, that was kind of messy, but yeah, there you go. What chapter? Oh, chapter 315. That was good. Sixth edition, Kyle says. Sorry, that was all chiming in while I was trying to read that. kept kept moving a sentence on me every time. That was as George said, great topic, great conversations. I believe Harmony wanted to continue this conversation in another topic. What happens when people do not disclose all information? Is that survey versus legal, or how long afterwards can a person bring up hidden information uh, forward to make a change, correction, or discredit what was done before? Um, Harmony has been on a
Yeah.
lot of our Wisdom Wednesdays, and she's got some. If anybody ever wants to do some pro bono work in Texas, please call me because Harmony would love your expertise in the kind of north of San Antonio area. I keep making that plea for you, Harmony. Somebody will watch one of these days. She threw her phone number in the chat, but I won't give that out online. I do have Harmony's phone number, so if you want to ever help with some pro bono work in north of San Antonio, Harmony will take you up on that. Hmm. Let's see. Jerry, generally, when a contract is clear on its face, it will be construed from the written language and enforced as written. The court has no authority to alter the terms of an ambiguous contract. And that was from Canfora versus Coast Hotels and Casinos, Inc. Oh, Nevada Supreme Court. All
Oh,
right.
there you
My own home state. George, you know about that one, George?
No.
I mean, I don't. Oh, I want Coast Casino. So that's got to be like the whole. Well, that's weird. That'd be Boyd Gaming, which would have been Coast Casinos and Suncoast, and interesting. I'll have to go. I'm gonna go look that one up.
I've been pretty lucky. I've stayed out of court except for one property survey and some water rights stuff, mostly water stuff. But that's easy compared to the land stuff.
To end up in court with a water case, that's even interesting.
Yeah.
Hmm. Very cool. I knew this would be. I knew this would go a long ways, all different
go.
places,
So
but
I'm glad we reached a general consensus.
yeah.
Yeah.
If you're taking the exam, Mr. Green owns the North 50 acres. If you have your license and you're ready to stamp, there is 78 different ways we're going to get to the South 50
Oh,
acres.
yeah.
Now you do exactly what everybody did here. What other evidence is there? Because
Yeah,
to
yeah,
try
yeah,
to determine it all on this
yeah.
is as we've seen impossible. There's too many open-ended sides of this. I just thought it'd be a nice follow-up to the original question because we always come at it from the other direction. How about if we come at it from the reverse direction?
Yeah. And George threw up in the chat a long time ago, and this is why we all drink. Whatever your favorite drink is, water, wine, or whiskey.
Good beer.
Yeah, or beer. As a young, see, like I didn't think we were gonna get an hour and a half out of this, but that's pretty freaking good. I love it. I thought it would be I thought it would be longer, but we've come to a good spot. We've come to a good spot. So anything what else? I love that you reached out on that one, Jerry. Thanks so much for taking a simple Confluence Daily Quiz exam question to a whole 90-minute conversation, which we knew we could, but that was awesome. George, the next one coming up will be October 20th, August. It'll be October 20th, but Rob McMillan sent me one again, and it was about basically equipment care and why you need to take care of your equipment and calibrate your rods and all these different kind of things. And it's going to be Marty Crook out of Monson Engineering in Reno, and Marty's done a lot of different presentations over the years on equipment care, so it's going to be it'll be a fun one. But I reached out to Marty, and he's going to do the next one for us, so it'll all be about why we need to take care of our stuff and calibrate our equipment, and calibrate our rods, and all those kind of things, and why it's so important. And Marty, when I reached out to him, Marty said he's been doing a lot of um, training with construction guys and construction those kind of things. And he says he's realized how important it is to teach that stuff even to surveyors and construction guys. So
We've been lucky up here in Reno because
yeah,
we've had access to Marty for
I know.
over 40 years, and
Yep,
his dad before that.
exactly.
But one thing I can say about Marty, his brother Dave is a crooked surveyor.
The real Dave Crooked surveyor.
Real Dave Crook. Worked with him for many, many
Yes, you
years.
did. Yes,
Great
you did.
guy.
So
And he's heard me calling that a lot.
there you go. I love it.
You wouldn't be shocked to hear that.
Yeah, and as Jerry threw in the chat, any of these other ones, great discussion by everybody. If we can have ideas for other mentoring Mondays, roundtable Tuesdays, this typically would have been a roundtable Tuesday, but I figured we might get a lot more participation tonight than we would if we did a roundtable Tuesday. So, and it did work out to be true. So we will see everybody in a couple weeks. Next week, if anybody's going to Minneapolis, it's the NSPS fall meetings. So if you're going to be in Minneapolis at those committee meetings and those kind of things, we'll see you there. If not, October 20th will be the next one. So Wisdom Wednesdays this week. We're going to go with chapter 1 on measuring America. That's the new book for this session. So a lot of fun. That one's a lot of fun. So have an amazing week, everybody, and we'll chat later. Bye, guys.